Alright, in this video, I'm going to recap the second week of jury trial of the 3 men charged with killing Ahmaud Arbery, and just like the first week, a ton of legal issues have arisen. Those legal issues include Georgia citizens arrest law and how that applies to this case, the judge reprimanding one of the trial counsels for their behavior, Reverend Al Sharpton's presence in the courtroom and the arguments that arise out of that, and lastly, everyone keeps on arguing about Bruton issues. We're going to define and go into all of these issues coming up. Hello, my name is Clyde Willamo, and I am a lawyer in the Chicagoland area, and in Law Talk for Non-Lawyers, we talk about the law in plain English. Now, before we get started, viewer discretion is advised, as this case does involve a homicide, the killing of Ahmaud Arbery. Also, if you didn't watch my summary of the first week of the jury trial, I'll go ahead and link that above, or if you would like to watch it after this video, I'll go ahead and add that link in the description below. So over the course of the second week of jury trial, the state presented a number of witnesses, videos, photographs, and other stipulations to show the jury what exactly happened here. And a brief recap is as follows. Ahmaud Arbery was jogging through his community when he came across a construction site of an unfinished home. He went snooping through that construction site, but ultimately did not remove any items from the site and continued along his jog. Gregory McMichael and his son Travis McMichael, they armed themselves, got into their pickup truck, and went to confront Mr. Arbery. Their neighbor, William Bryan, also got into a second pickup truck to assist the McMichaels in confronting Mr. Arbery. Now, in their pursuit, the McMichaels in one truck and Bryan in another truck, they cut off Ahmaud Arbery's path a number of times as he was trying to evade these individuals. Now, in a cell phone footage that was captured by William Bryan, we see Ahmaud Arbery's last moments on earth before he was fatally shot by Travis McMichael. So the first question here is, what is Georgia's citizens arrest law and how does it apply? And before we get into that definition, I first want to talk about another Georgia law, and that's the law of false imprisonment. And a person commits false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such person without legal authority. Okay, so generally speaking, a person in Georgia cannot detain another person in Georgia. Okay, that would be against the law. Now, the citizens arrest law is something that is an exception to that law. Okay, an exception to false imprisonment. And the exception is governed under their Code of Criminal Procedure, Section 17-4-60, which states, a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. There are two big things that are not covered by that statute, by that exception. The first thing is this. It allows citizens to detain individuals who are fleeing from felonies, but it does not allow citizens to detain individuals who are fleeing from misdemeanors. In Georgia, trespassing on another person's property is a misdemeanor, not a felony. So the question for the jury is going to be is whether or not Ahmaud Arbery was committing a misdemeanor or a felony at the time that these individuals decided to implement this detention or try to arrest him. The other huge thing that is not covered by this citizens arrest exception is this. It allows for the detention of a person, but it does not allow for crimes to be committed in acquiring that detention, okay? So your crimes that you do in order to detain someone, that is not covered by this exception. So this is something that the jury is really going to have to decide of whether this applies, whether this does not apply, okay? And ultimately, the other aspect that the defense is trying to raise here is a self-defense claim. Now, self-defense is something that I've defined earlier in another video, but I'll go ahead and define it for you here. A person is authorized to use deadly force if he believes that such force is necessary to prevent imminent death or great bodily harm to himself, okay? So the big question about the self-defense is, who is the initial aggressor, okay? Because you cannot be the initial aggressor and then claim self-defense. That would be contrary to the law in the state of Georgia. All right, next, let's look at the legal issue that arises from a lawyer being reprimanded by the judge. And I have that clip for you. Here it is.
You did not follow up to try to determine if a burglary had been committed at 220?
Objection. Once again, formal question, on what day?
He's already testified to what he did, and you've asked him, it was either you or
I don't know why I'm so confused here, Judge. Go ahead. I'm sorry, I'm following.
Ladies and gentlemen, if you could please take a step outside. Mr. Sheffield,
Yes, sir.
you can agree or disagree with this court. That is your prerogative. But to act in the way that you just did in front of this panel, disrespect, I don't care whether you like my rulings or not, or you like me or not, but in this court, the Superior Court, it is axiomatic that counsel show at least respect for what the court is doing. And what you just did shows a lack of respect for what the court is trying to do here, which is create an environment which is fair to all parties. I would suggest that you take a moment to think about that. I'm going to step off the bench because I found that, I'll just call it rude.
All right, it's never a good move to get on the judge's bad side, okay? And you may not know this, but in addition to all the education that us lawyers receive in order to be competent, to be able to practice law, there's also professional responsibility, okay? Many locations, including Georgia and Illinois, have a professional responsibility exam that all lawyers must pass, okay? And we're talking about the model rules that we should live by when we practice as lawyers, okay? Now, the model rules in play here are probably model rules 3.4, 3.5, and 8.4. Now, model rule 3.4 states a lawyer shall not knowingly disobey an obligation under the rules of a tribunal. Now, tribunal is just another way of saying the judge, okay? So the lawyer must follow the rules that are put by the judge in any case, especially in a jury trial, okay? Now, model rule 3.5 talks about a lawyer shall not engage in conduct intended to disrupt a tribunal, okay? And even worse, if it actually disrupts a tribunal, let's look at model rule 8.4. It is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. The eye rolling is never appropriate in court, okay? Lawyers should not be engaging in that kind of behavior, and it was completely proper for the judge to have the jury leave the courtroom and reprimand that lawyer for his behavior, okay? So the judge, that was one of the things that could have happened. The judge could have held him in direct criminal contempt for that behavior that happened in front of the jury, and there are other things. He could have fined them for that behavior in front of the jury. So that lawyer definitely benefited from the fact that the judge only gave him a reprimand outside of the presence of the jury, but this is not the way you want to behave in the middle of such a significant trial. All right, let's move on to the next legal issue in this case, and that is Reverend Al Sharpton. In the middle of week 2, he decided to come in and sit with the family of the victim, the Arbery family, and this was something that was commented on by one of the lawyers, and let's go ahead and take a look.
My understanding, while I was cross-examining Investigator Lowry yesterday, is that the Right Reverend Al Sharpton managed to find his way into the back of the courtroom. It's one thing for the family to be present, but if we're going to start a precedent, starting yesterday, we're going to bring high-profile members of the African-American community into the courtroom to sit with the family during the trial in the presence of the jury. I believe that's intimidating, and it's an attempt to pressure, could be consciously or unconsciously, an attempt to pressure or influence the jury.
All right, now you heard he does not want a prominent member from the black community potentially influencing the jury pool in this case. Now, there is actually a model rule that covers this very argument that the lawyer is making, and that's Model Rule 3.5. And that states that a lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by the law. Okay, so what the lawyer is arguing is that by bringing these high profile people in, it's possible that they are trying to influence the jury in their determination in this case. However, the prosecutor immediately went ahead and said, I didn't request, I didn't ask for this person to be here. And ultimately, this is a public trial, okay? And this is ultimately what the judge decided in this case.
I was asked at lunch whether the court had any objection to Reverend Al Sharpton coming into the courtroom, and I said, as a member of the public, there are certain limitations on what we can do here, what is going on. And what I was told was, instead of having someone from the family sitting in the courtroom, that he was going to be sitting there instead of somebody else from the family. And my comment to that was simply, as long as things are not disruptive and it's not a distraction to the jury or anything else going on in the courtroom, so be it. But if it violates the court's rules with regard to the conduct of the trial, or violates my orders with respect to how people are to conduct themselves in this courtroom, I will take it up with whomever I need to take it up with. Well, I will tell you that I noticed him once and that was it. And the fact that nobody else even noticed that he was in here means that everybody complied with this court's rulings on sitting in this courtroom and listening to the evidence.
All right. Now, I gotta say, the judge is doing a stellar job. He absolutely understands the Sixth Amendment right that is at play here, okay? The Sixth Amendment of the Constitution guarantees a public trial. It's the reason why the cameras can be in the courtroom, but it's also the reason why people can come into a public courthouse and sit on a public case, and that includes Reverend Al Sharpton, okay? He was not engaged in anything that was influential. Half the time people didn't even notice that he was present, okay? So that was something that was very proper of the judge to say, that this did not actually violate the rules, because at no point they were actually trying to influence the jury. All right, so let's move on to the last of the legal issues, which are the Bruton issues.
Because of the Bruton issues, the parties had discussed the Bruton issues contain Bruton problems.
Right.
One, because of the Bruton issues.
There are portions of the videos, however, that don't impact Bruton.
I understand that the Bruton issues have been addressed. Whether it is one of the Bruton statements.
Now, Bruton issues come from a Supreme Court case. It's actually Bruton versus the United States, and it was decided back in 1968. Now, let me give you the facts of that case. In Bruton, Bruton was one of the co-defendants charged with committing an armed robbery. The second person was his co-defendant, Evans. Now, Evans admitted that he committed the crime, but in his admission, he also implicated Bruton. Now, these two defendants were tried at the same time, and the problem that Bruton had was this. Because there was an admission that was coming in that implicated him, he would not be able to cross-examine his co-defendant, Evans. The reason he couldn't cross-examine Evans was because Evans had the right to remain silent. That's his Fifth Amendment right against self-incrimination. So he felt that it was unfair for the jury to hear in his case that his co-defendant had confessed to the crime and implicated him, okay? Now, what ended up happening was the judge said, I am going to fix this by telling the jury that they are not to consider the confession as it relates to Bruton, but they can consider the confession as it relates to Evans, okay? Bruton was found guilty by the jury. And what he argued on appeal was that even though the judge went ahead and gave this instruction, informing the jury that they are not to consider Evans' confession against Bruton, they would not be able to unring the bell. Once the jury heard that Evans admitted and also implicated Bruton, they ultimately were going to rely on that on finding him guilty. This went all the way up to the Supreme Court, and the Supreme Court sided with Bruton. They said that in a scenario where one individual admits to a crime and they implicate other individuals, and that first person who's giving the admission, they do not testify, this is something that is so prejudicial to the other individuals that it is just unfair. It does not result in a fair trial because they now do not have the chance to cross-examine a statement that was heard by their jury. Okay, so this is the issue that was raised in Bruton, and ultimately since that time, this is a great reason why cases are severed. They are severed so that one jury does not hear the evidence that's supposed to be going to another jury and vice versa. So when you hear the lawyers talking about Bruton issues, is whether information is coming in from one co-defendant that is going to be used to convict another co-defendant. That would be unfair if that person does not get on the stand and testify. Alright, if you haven't done so already, consider giving this video a thumbs up and subscribing to this channel. Next week, we will be recapping week 3 of the jury trial of the 3 men charged with killing Ahmaud Arbery. Alright, take care. Bye-bye.